I'm starting by the name of Almighty Allah, the most gracious, most merciful. Peace be upon you, viewers. I'm presenting here today's my Evidence Act Lecture 3, and here I'm speaking in English, or I'm conducting this lecture in English for the people, those who don't understand Bengali, and for non-Bengali speakers, especially those who speak another language. For them, I am speaking and I'm conducting the lecture in English. So today my lecture is Evidence Act Lecture 3. Today I will discuss sections 1 to 4. Section 1 to 4 I will discuss today. So section 1 discusses section 1 is with a title, extent, and commencement. Three things here in section 1: title, extent, and commencement. What is title? What the evidences will be called? What will be called evidence, and what the name will be of this act? And the act will be called as the Evidence Act 1872. 1872. This title and extent, where it will be used without five cases, or except 5 cases. Evidence Act will be used everywhere, and every cases in every act or law, but in 5 cases, or in 5 things, or in case of 5 searches, Evidence Act will not be used. What are 5 5 acts, or 5 things? This Army Act 1951, Army Act 1951, and Navy Act 1953, Air Force Act 1961. In 61, and in arbitration and in affidavit. In these 5 cases, Evidence Act will not be used. Without these 5 cases, evidence will be used in all of the cases, and all of the in all of laws. So the extent and commencement. Commencement means when from it will be used, and the law will be used from 1st September 1872. From 1st September 1872, this law will be effective, or it will be used, or it will be enforced. Okay, and section 2 is omitted. This is omitted. And section 3, interpretation or definitions. In these interpretation definitions sections, there are 9 definitions, or there are 9 interpretations. So first interpretation or definitions, code. What is code? In the eye of Evidence Act, code is not with that we think on code building. Building is not called code, especially in this in the eye of Evidence Act. Code is magistrate, judge, or persons who is empowered for taking evidence, or for the taking witness, or witnessing or evidence. This is called code. So I think that you have understood what is code in the eye of Evidence Act. Evidence Act and a code is something different. So now we come to the fact. What is fact? In the eye of Evidence Act, fact is not that we commonly think. Fact is that can be seen, that can be touched, that can be caught, and that can be felt. And that can be smelt, that can be weighed. Such kind of thing will be fact in the eye of Evidence Act. And Evidence Act, fact is something difficult. You may not understand easily reading, and there I told this, you will get hint of such kind of such kind of speech that I am talking about. A fact, you will get hint directly. You will not get that hint is this, and that can be seen, that can be touched, that can be caught, and that can be felt or smelled. This will be a fact in the eye of Evidence Act. Now you come to relevant. What is relevant? Relevant means with your main subject, or main occurrence, or main topics, if anything coherent and there is matching with it, and relevant, related, if anything is related, it's called relevant. But this relevancy must be, or the relevant matter must be from section 5 to 55. If this relevant matter is in section or fall in section 5 to 55, then you will think that it's relevant, otherwise not. Now come to the point that this is, now I will explain fact in issue. What is fact in issue? Fact in issue is such kind of things. There's a one party claim, or one party claim or complain, or another party denies. One party claims, or one party complains, another party denies. Such kind of thing is called a fact in issue. Suppose example, A complained that B has beaten him, but B is denying the matter. Now fact in issue is that whether or either B has beaten A or not. This is the fact in issue. This is called fact in issue. Document. Now come to document. Document, we especially understand the paper. When paper is document, one registration paper or land registration, such kind of thing we think that. But in the eye of evidence, document is something different. Document is such things, any letter, any sign, any symbol, any writing on any matter, on any object, on any substance, on anything. This is called document. Example, suppose on label, suppose pen on label writing matador. So the writing matador, the label is document of the pen. So and stapler, suppose in stapler label writing kangaroo. So kangaroo is here, writing kangaroo is document of this stapler. Okay. So I hope that you have understood what is document in the eye of Evidence Act. So now evidence. What is evidence? So evidence, here are two types of evidence, especially in Evidence Act. One is oral evidence and documentary evidence. So oral evidence, when witness state something, or is witness deliver his statement, or give his statement, or say something shoot related or case related matter, or say something, or tells, or states, or especially statement of witness is called oral evidence in the Evidence Act. And if anything or any document is submitted, or any document is submitted in court for proving, this is called documentary evidence. Now proved. What is proved? Proved is such thing when anything is submitted in court for submitted in the court for proving, or any document or anything given. If court believes that this, that will be proved. And what is disproved? Disproved is such things when any document or anything is submitted for court for believing, but court does not believe the submission. So matter there you presented in the court for believing, but court hasn't believed, or court didn't believe. When court doesn't believe either a document, then it will be disproved. It's called disproved. Now not to be proved. What is not to be proved? When any party hasn't submitted or presented anything for proving yet, understand, then it will be called not to be proved. And if anything submitted for proving, it will be either proved or disproved. But when anything hasn't submitted yet, it will be called not to be proved, because court hasn't I believe this, and also they don't believe. That means it hasn't been presented here for proving, so it's called not to be proved. Now number 4, presumption. In these sections, three things focus here. Three things here topics, subtopics are three things. These are may presume, shall presume, and conclusive proof. May presume, shall presume, and conclusive proof. May presume. If you get may presume in any of the sections of Evidence Act, when you study, then you think that court will consider this proved until or unless it is disproved. Until or unless it is disproved, court will consider that it is proved, and court will call the party for proving. And now shall presume. If you get shall presume in any of the sections while reading and when you study book, then you think that shall presume, then could you consider this or regard this as proved until or unless the party concerned disprove this and court will not call for proving this matter. Okay, so conclusive proof. Conclusive proof, that means court will think the document or that is submitted is 100% proof, and court will not allow anything for disproving this. If anybody or any party want to try to disprove the matter, conclusive proof, if any party want to disprove, court will not allow this. This is conclusive. Suppose conclusive proof, Evidence Act 112 sections told that if any child is born within 280 days after divorce, this child is legitimate, and this is legal, very legitimate child. Court will think this, and this is conclusive proof, and no proof will be, and nothing will be allowed to disprove such kind of matter. Suppose shall presume. Power of attorney, section 85 shall presume. Here you see that writing shall presume. Power of attorney, court will shall presume. Court will I think that, or court will regard or consider that is proof until or unless it is disproved the party, and court will not call for proving. Court will not call this for proving. And now may presume, I think that you have understood. May presume. Evidence Act, Evidence Section 90. Section 90 told that 30 years old document court will presume, may presume here. So 30 years old document, if submitted, court will think that this is proved until unless party they are concerned disprove this, and court will call for proving the matter next. I hope that you understood, or I am pessimistic about this lecture today. I know that you have understood this, and if you don't understand any of the points or anything to this lecture, you may inform me. So in my today's lecture, if any lackings or wrongs or any mistakes you get or you find kindly pardon me. Peace be upon you. Okay.